Hi, everybody. This is Jeff Fowler with the Apartment Owners Association, and it's great to have you with us today. We're going to be covering security deposits. And, we are really dedicated to your real estate success, and security deposits is a thing that gets, there's so much litigation around that, so many disputes. And so hopefully the attorney today will be able to bring some clarity. Before we get into that, just want to mention the live investigator search that we have with AOA tenant screening. And as you may know, many of the counties in California have they've redacted the date of birth or some other personal identifying information from the county reports. This is happening at a county level, which makes it extremely difficult to get an identification and be able to, for the tenant screening companies, for them to be able to show you the information. And so when they can't show you the information, then you go without it. But the live investigator search, what we've done is we've hired a private investigator, and they actually do it by hand, and they're able to look at a lot more data than just what a software program hitting a database. And so they're able to give you more information there. They also do a civil search, which is going to show, of course, evictions, but also civil misconduct. So if there is domestic violence or stalking or other things that should not be tolerated anywhere really, but especially in multifamily, you're going to get that report as well. And it's all starts with a social security trace, and they go by the addresses that are listed there, and they'll do a county search in so many different indexes for all that. So I want to really encourage you to use that, augment what you're using. Today I got off the phone with a investigator in the Department of Justice at the state level here, and they're talking about stolen identity, and they needed some information from us, not your information, but just general information. But man, it is a thing. So I may have mentioned it last time, but really look at the driver's license, make sure that that's real, because they're taking people's identities and pretending that that's who they are. And it's a complex web. So really handle the driver's licenses, look at them. There's places where things should be raised. You should be able to bend that. Anyway, so there's a whole lot there to really just pay close attention to. And anyway, so yeah, getting into this thing. Man, we have a lot of different things on the website, on our YouTube channel. So you may be watching from AOAUSA.com, but if you go to the YouTube channel, which is AOA USA, you'll see all kinds of stuff. And our speaker today, he did a maximum allowable rent increase seminar not too long ago. Move in, move out crash course. Yours truly did a tenant screening crash course. This is the Social Security crash course, or I'm sorry, security deposit crash course. And anyway, a whole lot of information there, but what you really don't want to miss is the free $1 million trade show at the Long Beach Convention Center. We're going to have over 150 different vendors that are there, over 20 seminars, and it will be great. We're going to be doing some new things as well. There'll be a panel. There will be a speaker talking about midterm rentals. And if you don't know what that is, come on out and you'll find out. And we are doing a toy drive with that in conjunction with the Union Rescue Mission. So if you bring a brand new unwrapped toy, then they will be able to get that to kids that are needy. So that's a cool thing that we're doing with that. And if you're watching on AOAUSA.com, there's the blue little help bubble on the bottom right side, and you'll be able to put your questions in there and they'll get that over to me. But why don't you listen first, and then also if you're in the Zoom call, you can just raise your hand and then we'll get to you. And anyway, yeah, so many different things going on, but let's get to it. Our speaker today has done over 250,000 evictions, over 45 years of experience, 29 attorneys on his staff. He writes the legal Q&A for the AOA magazine. So if you're getting the magazine, look for that article, that column's in there every single month. And so our speaker is also the founder of Dennis P. Block and Associates. So Dennis, it's great to have you with us today.
Be with you, Jeff, and thank you for allowing me to join your forum. And of course, for you members out there, how invaluable it is that you get these lectures on all kinds of subjects. Our industry, of course, is under attack by politicians, the media, by tenants, and we really have to know exactly what we're doing and to comply with all these rules and regulations that get changed literally minute to minute. So it is for the people who are listening now, I take my hats off to you because you want to make sure that you're running your operation correctly. By the way, Jeff, with regard to that $1 million trade show, did you mention that the admission was $1 million for each person? I missed you. Anyway, I'll be speaking there at about 1:15. And I think that's August 20th, and that's at the Long Beach Convention Center. I'm going to be talking about how to avoid discrimination and habitability lawsuits. That's the new thing that's happening now is that, and I liken it to that there are so many attorneys that are running these personal injury commercials on TV, and the market for them gaining cases is very difficult because so many people are looking for it. So what these attorneys have done is they've now looked towards the landlords to as their new meal ticket and suing landlords either for discrimination or they're suing for habitability. So definitely come on out August 20th. I'll be speaking at 1:15 and you really need to protect yourself. But today, we're going to talk about everything you ever wanted to know about a security deposit. And I always find it very humorous that every landlord, without question, knows immediately to take a security deposit. Everyone knows, but very few know what to do with it once that tenant vacates. And in terms of small claims court lawsuits against income property owners, the number one reason why income property gets sued in small claims court is because of failure to properly dispense the security deposit or to account for it. So, what do you have to know about security deposits? Well, first of all, there is no such thing as a last month's rent deposit. That's considered a security deposit. In fact, it's not to your advantage to even call it a last month's rent deposit. So never take a last month's rent deposit. There is no such thing in California as a non-refundable cleaning fee. You don't take a cleaning fee. You take one thing and one thing only, and that's a security deposit. And I'll tell you in this broadcast what you can deduct from that. Also, there is no such thing as a pet deposit. That doesn't exist. It's all considered a security deposit and nothing else. Now, how much of a security deposit can you take when the tenant moves in? And the answer is, under new laws, unfortunately, whether you have a furnished unit or an unfurnished unit, you're only entitled to 1 month's rent. Only 1 month's rent on a security deposit. So if your rent is $2,500, you're limited to the first month's rent and a $2,500 security deposit. Now, there is an exception, and the exception is that if you own two properties with a maximum of 4 units, then you were entitled to a security deposit equal to 2 months' rent. So that would be let's say a triplex and a single family home. That would be two properties with a total of four. So it doesn't exceed four, so you'd be able to get it. The other way that you can kind of get around this would be if you have two 4 unit buildings, you could put one of them in an LLC, and the other one you could either put in another LLC or in an individual's name on that basis that the owner owns no more than 4 units in two buildings. That's one way to get around it. The other way to get around it would be to take a 1 month security deposit, but in California, you are allowed to demand or ask the tenant to pay advanced rent, but the advanced rent can only be 6 months to 1 year. It can't be less than that. So you can tell the tenant, yes, I want 6 months rent in advance plus the security deposit. Sometimes when you're dealing with people with poor credit, that might be a way to make you feel more at ease if you're getting 6 months to 1 year's rent plus the security deposit. Now, when the tenant does move in, okay, you want to make sure that when you get that security deposit, be it 1 month or 2 month, if you meet the exception, and of course your first month's rent, you want to make sure that you do not give possession of that unit to your tenant until those funds have cleared. The funds must clear. So you can take a personal check, you can take a cashier's check, you can take anything you want, but you're not going to give those keys. You're not going to allow them access to the unit until those uh, monies clear your bank account. Now, I've had it where, believe it or not, people give a cashier's check. You would think that would be pretty uh, for sure that it's going to go through. But the reality is you can put a stop payment on a cashier's check. And in some cases, and I've seen more of this, they give you counterfeit cashier's checks. I mean, it looks like Wells Fargo, it looks like Chase, but it's a counterfeit and they gain access to your property. So again, regardless on the fees moving into your unit, make sure that those funds clear before allowing access to the unit. Okay, so you have a security deposit. Everybody knows to take it, but what do you do with it? Well, first of all, you don't have to put it in any kind of a bank account. You can take that security deposit. You can go to Vegas and you can put it on, roulette or blackjack. You can do whatever you want with that security deposit, but you do have to account for it once that tenant vacates. Okay. So how do you account for it? Well, this is what you're allowed to deduct. Number one, you're allowed to deduct for unusual wear and tear, reasonable and actual cleaning charges, and any unpaid rent, those items that are considered rent. So I always get questions as to how do I know if it's unreasonable wear and tear or if it's reasonable wear and tear. So let me give you the definition. Reasonable wear and tear refers to the normal deterioration of a property due to everyday use over time, as opposed to damage caused by tenants' negligence, misuse, or abuse. And that can be, for example, like faded painting or minor scuffs on the wall, worn carpet. Those are considered, or nail holes, those are considered usual wear and tear. But if you see cabinet doors ripped off and window screens ripped, draperies pulled down, that would probably be considered unusual wear and tear. By the way, you cannot deduct late charges from a security deposit. And the reason for that is you're only allowed to deduct rent, and late charges is not considered rent. You might have a phrase in your rental agreement that states that all monetary obligations are considered rent. If that's contained in your rental agreement, then you would be able to deduct all those late charges that the tenant uh, incurred as a result of not paying their rent on time. Okay, so now you know what you can deduct from that security deposit once the tenant leaves. Once again, unusual wear and tear, reasonable and actual cleaning charges. So if you're going to like hire a company, XYZ cleaning company, and they charge $275, then that's what you would deduct from that. And then finally, of course, any unpaid rent. So let's take a look at that security deposit form. And there is an excellent one if you're a member, and it's on the AOA website. And I think I am sharing that now. And as you can see, this security deposit itemization is fillable. So you can type into it, as I will attempt to do right now. So you would put in the names on it, and then of course you would fill in the address, okay, and the amount of the security deposit. If you do own interest on security deposit, then you want to include that too. Now, interest on security deposit is really for very few jurisdictions. One of them, of course, is Los Angeles, that technically has to be paid yearly. So if you're in the middle of the year, you don't have to pay it if the tenant moves out. And technically, it's supposed to be paid on a yearly basis, and it does change the interest rate from year to year. But as you can see here on this form, which is perfectly provided for you, you have the rent that's owed over here, and then you would fill that in, $2,500 or $5,000. And then you would put in the actual cleaning costs, unusual wear and tear, and then you could list that. Then it's either going to show that there's a balance to the owner or there's a balance to the resident. If that's the case, then you're obviously going to send them your personal check for that. Otherwise, as this form goes on, it tells them that if the tenant owes you money, this is where you're supposed to send it to. So that's their security deposit form, which is an excellent form, and again is available to all members of the AOA. And I do encourage you, if you're not, to join the AOA because it is a really good organization. If you are deducting more or $125 or more from that security deposit in terms of unusual wear and tear or for cleaning charges, then you have to include the receipts. So, or at least an estimate if you don't have the receipts at that time. So make sure that those are included when you mail out the security deposit form, and you should be mailing that to the tenant's last known address. So if he gave you a forwarding address or if you know where they work, mail it there. If you don't know where they moved to, then mail it to the last known address, which would be the same address that the tenant vacated from. Now, in terms of deductions, if you do your own cleaning or if you have your manager do your own cleaning, are you allowed to deduct for that? And the answer is yes, you can. You can deduct, you keep track of your hours and charge a reasonable hourly rate. I'm not sure exactly what that is, but they're paying fast food people $20 an hour. So I would think cleaning a unit should be more than that. So let's try at least $35 an hour. And that would be what you would be including in your deduction for the extra unusual wear and tear or for cleaning. Okay, now, if you can't get these estimates or invoices within the 21 days, you have an absolute obligation to still send that security deposit itemization within 21 days. You would want to write in it that the work hasn't been completed or the receipts are not available, and I will get them to you as soon as they're available, and definitely do that. So you'll do a follow-up. But you've got to mail that security deposit itemization within 21 days. And when you do that, it's always a good practice to go to the post office and get a proof of mailing. You don't have to mail it by certified mailing, but at least a proof of mailing. Now, can you email it to the tenant? The answer is you can only email it to the tenant if that's provided for as a term in your rental agreement, that emails are proper forms of notices. But if that's not in your contract, you need to mail it. Of course, you can hand it, but you need to mail it to the tenant at his last known address, and that would be your property, assuming he didn't give you his forwarding address. Okay? Now, this is how landlords always get sued in small claims court, that they don't do anything with that security deposit or they wait more than 21 days. If you wait more than 21 days, then the tenant, quite frankly, is entitled to his full security deposit back. And if you don't do it timely and you get sued in small claims court, there are additional penalties. If it's held that you withheld that security deposit in bad faith, if it wasn't just a careless mistake, I was on vacation and I got it to you on the 22nd day, then they can sue for an additional amount of two times the security deposit. Two times the security deposit. So you want to make sure that you do accurately and conservatively make deductions from that security deposit. And you also want to make sure without fail that you mail it in 21 days. In fact, be wild, mail it in 20 days. You're not even close to that 21-day cutoff. Okay, what else is there with regard to security deposits? Well, the law requires that within 15 days of the date that the tenant is going to vacate, that you offer the tenant a right to a move-out inspection. So let's share my screen with that. Again, this is a form that's on the AOA website, which is excellent. And what the concept of this form is that it gives the tenant a chance to make corrections to the unit so it won't be deducted off his security deposit. So you are required, if the tenant has served you a notice that he's moving, let's say, by the end of let's say August, or you have served him a notice and he legitimately has to move by the end of August, then within 15 days of that termination notice, you have to send him this form inviting him to do a walkthrough. And then the two of you will walk through the unit, and then you will point out to that tenant what things you're going to be deducting from the security deposit and giving him a chance to make those corrections so it's not deducted off of his security deposit. This is important because if you don't do this, again, you can get sued in small claims court, though they don't really have a mechanism for a penalty if you don't do this. But again, I can see some small claims court judge saying, well, you didn't serve this pre-move out inspection form, so I'm going to rule that he's entitled to his full security deposit back. I mean, that's just the way it works with regard to these types of items. So we now know, again, what we're going to do when a tenant moves into your unit in terms of what you can ask for. We know that we're going to get those fees in that have cleared before we allow entrance into the unit. We know what deductions you can make from that security deposit, which is, of course, reasonable cleaning charges, unusual wear and tear, and of course, any unpaid rent. We know that the security deposit form must be mailed to the tenant's last known address within 21 days, and that we have to also, for safety's sake, get a proof of mailing from the post office. But there's one more thing we need to talk about, and that is under new rules, the state of California has forced you, each and every one of you who has taken a security deposit, they force you to be a photographer. Yes, ladies and gentlemen, you are now forced to be a photographer under the laws for the state of California because right now, today, when you lease a unit, you must take pictures of that unit, which you're going to save. And by the way, I think this is a good idea, showing the condition of the unit. So you want to take pictures of the cabinets, take pictures of the windows to make sure that none of them were broken. Take pictures of the carpeting, take pictures of everything and just save them. But according to the laws for the state of California, you now have to have pictures of the condition of the unit. Now, I think this is really good, quite frankly, because when the tenant claims I didn't break that, well, the door on the oven was never there. So this way you have photographic proof as to what the condition of the property is. And this really will come up when you go to small claims court, assuming you're summoned, that you can show Your Honor, this is what I deducted for. Look at the apartment I gave him. Look what I got back. Okay. Now, in addition to taking pictures before you lease out that unit to the new tenant, there's more things you have to do. And that is any time a tenant vacates a unit, you have to take those pictures as to the condition, which makes sense, of the unit when he vacated the unit. So you want to take pictures of any of the damage that he caused. Maybe there's rips in the carpeting. Maybe there's crayons on the wall. Maybe there's just a cracked pipe that you could tell only got cracked because somebody took a sledgehammer to it. So you want to take pictures of those. And then the law requires one more set of pictures. That is that you have to take pictures after you restore the unit, after that tenant vacated. You have to take the pictures of how the unit was restored. Now, these pictures of after the tenant vacated and after the tenant was restored has to be given to the tenant as part of the security deposit itemization form. So you're going to include those pictures too. In addition, as I mentioned, you're going to include any receipts or estimates showing any work that was required where the total amount of work was $125. So right now, as we know, everybody's got a smartphone, so take pictures, never, never erase them. Keep them for at least 5 years after the tenant vacates the unit so that you can prove to the world that you were in compliance. So once again, once that tenant vacates, take those pictures. Once the unit is restored, take those pictures and include those pictures with the itemization. Again, if you don't finish the work in time, you're still going to send the tenant an estimate at least as to what the cost of the renovation was to that unit and mail that within 21 days. And then you'll send them the after pictures and any receipts that you garner thereafter. And that, ladies and gentlemen, is the crash course on dealing with a security deposit. And now, my good friend Jeff, if anybody's got questions, I'm ready to answer them.
So let me go gallery view here, see if there's, okay, no raised hands, but we'll start with questions here. Patricia is asking, what if holes in the wall are large and seem excessive? So like, when they're, probably like when they've put a nail in the wall to hang a picture. What if those holes are excessive?
And normally, and if you look around my office, and oh, I don't see any in yours, Jeff, but if you look around my office, you're going to see that there's pictures hung on the wall. That's going to be normal wear and tear because everybody's going to put up pictures when you're dealing with a tenant. It's just the way it is. So normal wear and tear would be pictures, and that's going to require the landlord at his own expense to spackle that wall and paint it. However, if you've got, chunks and chunks and pictures every part, that's not going to be normal wear and tear, and that you'd be able to deduct for, of course, gaping holes and anything else that did not occur naturally.
Great. All right, Diana, can you go ahead and share your question with us?
That's a good question, and the answer is absolutely not. It's only when the tenant or yourself served a valid termination notice, not when you're in the middle of an eviction case. And I meant to mention that, so Diana, I'm glad you did. By the way, anybody else who's in the Zoom room, if you look at the bottom of your toolbar, you're going to see an icon that says raised hand, and so Diana has done. So if you do want to talk to us, directly, then please electronically raise your hand. But we'll also get to the people who are in YouTube as well. But thank you, Diana. Good question.
Yeah, and then Diana, oh,
Go ahead. No, no. If you're in the middle of an eviction case, you've served a fault notice on the tenant, like a notice to pay rent or quit. There is no requirement that you use this notice. Now, even if you're in the middle of an eviction case and the tenant's evicted, once that tenant's evicted, you still have to comply with the laws dealing with a security deposit, and you still only have 21 days to do so.
great. Oh, hold on, Diana. Let's let other people ask questions, and then we can swing back around to you, maybe at the end, because we have good 30 minutes to take questions though. But Mary Ann, can we get her unmuted? And
Not exactly. You're entitled to an advance rent payment from anywhere from 6 months to 12 months. and that would be for the first 6 or 12 months of the tenancy. So you can't kind of like try to make it into a security deposit. That has to go towards the first 6 to 12 months of the tenancy. Well, it's 2 units on one lot. Is the garage attached to the house or is it separate? We understand that, but is the garage attached to the main house? Okay, so that's not a duplex. A duplex is one structure with 2 units. So, but in any event, it's still going to be considered, if you're talking about LA rent control, it's still going to be considered two dwelling units on one lot, so it's going to be subject to rent control.
Great. Thank you, Marianne. All right. Who else has a raised hand? Yeah, Patricia, raised hand.
Yeah, the city of Los Angeles has it at 4.3%, insane for the year 2025. So, yes, I think the code does provide that if you do keep it in a bank account and you can prove that, then it's whatever the interest is that you're getting from the bank. This never had happened. This never had happened before because normally the interest rate was less than 1%. And all of a sudden, some Yahoo at the LA City Council decided that 4.2% was the correct. By the way, I'd like to get 4.2% if you could tell me where to get it.
Tell me about it. Yeah.
But but the reality is that I think that if they're going to keep it up, then I would say yes, that the you should put all the security deposits in one bank account, and you'll be able to see what the interest rate is. That is accurate.
All right. Well, we'll
We'll
look
get
at the
back to you.
chat and let's go on to Letha. And if you remember it, Patricia, and there's time, we'll get back to you.
If you got one building with 5 units, you can only get a 1 month security deposit. There's no way around it.
Great, short and sweet. There we go. Let's see what we have here. Wow, lots of questions. What is good verbiage for charging for cleaning when tenants claim they are professional cleaners and left the unit professionally cleaned?
Well, I mean, the reality is if they did, then you shouldn't be charging for cleaning. But if you look at the unit and you say, this is not the way that I leave the stove, this is not, we do some expert cleaning like vents and other stuff, which you didn't do. So we're going to charge you for that.
Okay, and so on or before the 21st day, are the itemization form and the return of security deposit funds due, or just the itemization form?
No, with the itemization form, if the tenant is entitled to a refund, you got to send that with the itemization form.
Okay, so does this include for evictions as well? Returning the
Yes, of
security
course.
deposit.
If once the tenant is out, then you're going to need to send him an itemization form. And normally you're not going to give him any money because he probably owes you much more money than the value of the security deposit.
Yeah, and botched repairs, obviously, that's something that if they didn't repair it right and you have to repair it, you're just gonna Should give them the invoice, right, for whatever you spent, or deduct it
Correct.
from the security deposit. And then could you review the refund with 6 months in each year? Patricia, okay, she asked that one. So I'm not sure what she, yeah, could you?
I don't think so because the security, I don't think so because I think the security deposit has to be paid yearly. If they move out before the year, I don't think any security deposit's owed. There's nothing in the, oh, I see what you're saying because it got cut off. Yeah, then I would do the proration between the two interest periods. Good question.
Right, here's a good question. My tenant had fiber internet installed in my property without getting written authorization as stated in the lease agreement. The holes are not sealed properly and can cause damage to the unit. Can I deduct fixed costs from the security deposit?
Absolutely, that would be considered unusual wear and tear. And so the amount that it's going to cost to repair those issues can definitely be deducted from the security deposit. Make sure that you do take pictures.
All right, yeah, and if the security deposit is 1,000 and the tenant has lived in the unit for more than 4 years, how does the interest work in this situation?
Well, again, not every municipality requires interest on security deposits. Most people are dealing with Los Angeles, which does, and that's for RSO properties. So you need to, on a yearly basis, send that tenant a check as to the interest incurred for that 1 year period.
And if they failed, if they didn't know they had to do that, and here they are 4 years later,
Would then write a check out immediately. The way
yeah.
this is becoming a big issue in eviction land when you have these municipalities require interest. And Los Angeles says that if you make any violation of our ordinance, that that's a complete defense to an unlawful detainer. So you could have, for example, a tenant that owes thousands and thousands of dollars, but yet he wasn't given his interest on his security deposit on a yearly basis. So the interest was maybe $6, $7, and yet you can lose a case, and we have lost cases on the basis that the security deposit wasn't paid.
All right, and then we have RW, and they are asking, after the tenant moved out, the carpet with stains and black with dirty, can we deduct partial carpet replacement from the security deposit?
You are, of course, allowed to deduct for cleaning. So if you can clean the carpeting, fine, that's permitted. But if in fact the carpeting it was unusual wear and tear where it's stained and you can't, then yes, then you can charge him for the replacement of the carpeting.
Okay, it says when questions are being asked on Zoom, we are not hearing the questions on the YouTube platform. That's
Interesting.
a,
So they can't hear it on that route. You know, I am, as people know, I do a weekly show every Saturday, and we do it on Zoom and YouTube, and they don't seem to have any issues with that. I'm just wondering if it's that specific person. So drop
yeah.
a chat, somebody else in the Zoom room, if you could hear, in YouTube, if you could hear the caller on Zoom.
All right, here we go. The tenant cashed the security deposit check. Can they still sue for deductions?
Absolutely. They don't have to you know, if you owe the tenant, for example, $2,000 and you only gave him 1,500, he can take the 1,500 and still cash that check and still proceed forward to sue you for the difference.
Here's a really good question. Do photos of the unit before move in and after move out need to be date and time stamped?
Well, they don't need to be. You would be your testimony when they were taken. But generally, almost all photographs, when you take them with a cell phone, do date stamp them automatically if you go into the media description of the photo.
Okay, Kevin's saying, hey, please ask the questions on YouTube. And really we kind of just finished through the Zoom ones and we'll nail some of these. Dennis had a nice, sweet presentation so that we could do lots of questions. So here we go. Kevin, you're the first one there. Section 8 tenant moving out, not paying her last month rent portion. Can it be deducted from the security deposit? No mention
And
of this in her lease contract. I inherited a tenant who's moving out. I am obligated to pay the interest portion stemming, or am I obligated to pay the interest portion stemming from the previous landlord ownership?
Good question.
so, bear with me one second. So yes, of course, you're allowed to deduct for any unpaid rent from the security deposit, even though excuse me, any unpaid rent from that security deposit. So if she failed to pay the last month's rent, of course you can deduct that. Uh, if if in fact there was interest owed, and we're talking about again the city of Los Angeles, and it hadn't been paid in at all or in the last year, then you do need to make that payment of the interest on security deposit, or at least account for that for the security deposit. Like you're going to increase the security deposit by the amount of the interest that wasn't paid.
Yeah, and then what about if there was a previous landlord that did not pay the interest portion, they're still obligated for it. Is that right?
Unfortunately, you are obligated.
And when they pay, can they pay via Zelle or does it have to be a check?
A lot of landlords love payment through Zelle, so I don't have a
Reminder.
Oops, let's get rid of that. A lot of landlords love receiving payments through Zelle. I don't think that you can make that as the sole method of payment. You can make it where it's going to be paid to a bank account, and you give them the bank account number and you give them an address of the bank within 5 miles of the property. That's one way to do it. Of course, it's also proper to tell tenants to pay to a PO box or to a rent collection box on the property or to the manager or to any kind of an address.
Right. Okay, John on YouTube. We're limited to 1 month maximum. I'm fine, but I thought it was 1.5. Do we need to offer interest on security deposit in California? This is really talking about LA City, correct?
Yeah, I mean, well, all the state of California deals with only 1 month's rent equal to a security deposit that you can take, unless you're that exception. But with regard to interest, that really only applies. There's other municipalities that I don't have the top of my head, but there is interest, of course, for the city of Los Angeles for RSO properties.
Okay, Silverback. What about the life expectancy on carpet, flooring, or tile and showers? Does the right to inspection notice apply to evictions? Okay, that's another question. So what about the life expectancy of carpet, flooring, or tile and showers?
Well, I mean, I think it's reasonable that if a carpet life, for example, is 8 years, and now the tenant moves out at the end of 7 years, but you see dark stains and everything else, should you charge him for the replacement of the carpeting in full? And I would probably say no. I would do a proration.
All right. Does the right to inspection notice apply to evictions due to non-payment of rent?
One more time with that question.
Okay. Does the right to inspection notice, like the
Notice to access the dwelling.
yeah, apply to evictions due to non-payment of rent?
If you need to access the unit, whether you're involved in an eviction case or not, you certainly have that right under the Civil Code, which is 1954. So if something is broken in the unit, you certainly have the right, even in the middle of an eviction case, to go in. It's interesting that every time you're evicting a tenant based on non-payment of rent, they're always going to claim that it's uninhabitable. So if that, and they list what's wrong. So on that basis, you have every right to serve an access notice. So again, these forms you can get from, of course, the AOA, and you serve that notice 24 hours in advance, stating the date, time, and reason. And you could say, because you claim that these things were wrong, and list them, and then you are allowed to go in. By the way, if the tenant's not there, and he doesn't have to be there, you can use your own key to get in as long as you served a proper access notice. If you don't have a key, you can actually hire the services of a locksmith to open up the door.
All right, Christine, broken mini blinds, is that unreasonable or reasonable wear and tear?
I don't know, do mini blinds break by themselves or do they break because, somebody crashed into them? So I would think that that would be considered unusual wear and tear. Now, if the mechanism of the blind is shot, and that could be from just use of that blind, then I would see that that would be considered usual wear and tear.
Okay, EO Chan on YouTube, if you are mailing the security deposit check, should we use certified mail?
You can certainly use certified mail. I certainly wouldn't do it where they have to sign for it. Just do regular certified mail, not return receipt requested. But again, it's just as easy to and cheaper to get a proof of mailing from the post office.
Okay, hold on. All of a sudden, I lost the questions. There they are. Okay. What about hazardous waste tire disposal? What if the damages are, yeah. What about okay, so basically they're going to charge for the whatever it costs them to dispose of those crazy things, right?
Absolutely.
All right. And then what if the damages are over the security deposit amount?
Well, then, as that form indicated, it's going to show balance owed to landlord, and then you fill in where the tenant is supposed to send that monies to that he now owes. Now, of course, if he doesn't do that, then your options are you can sue in small claims court. The current jurisdictional limit of small claims court is $12,500.
Okay. What happens if the former tenant doesn't cash the security deposit reimbursement check if they claim that they never received it?
Well, if you have proof that you mailed it, then I would send them a follow-up letter telling them, okay, I'll put a stop payment on that and we'll send you out another check if you've lost it or if it just didn't get there.
Yeah. With regard to the photos that are now being required when sending the security deposit reimbursement check, how long should you hold on to those photos after the tenant moves out?
I would say at least 4 years.
All
And
right.
again, you don't have to hold on to them because they are electronically stored. So nothing to hold on to. And storage is so cheap. I know Google Photos, you get, I know, 15 gigabytes at no charge. So, and actually, if you have an Amazon account, if you have the Premier Amazon account, if you're a Prime member, it's unlimited storage. So since you have a Prime membership anyway, you can store all of your pictures for ad infinitum. These are these technical tips that you also get from the AOA.
There you go. So Jeanette, paid interest on security deposit requirements. So you'd mentioned that you need to pay that every year. We're talking about Los Angeles, and what other are there any other requirements there to
Not that I'm
mention?
aware of, just every year send them that check with, a computation as to how you got to it.
Yeah. Okay. Equity Pro management. What kind of recourse do tenants have if the landlord does not send them pictures of the unit when they move out?
Well, technically, they're not in compliance with the law, but I don't know that they have, quote, any penalty for that. I don't think that your security deposit itemization is now considered void because you didn't send the pictures, but who knows what a judge is going to do in small claims court or even in another court. So the trick, follow the law, and that's why we do these seminars.
All right. Can painting be deducted from the deposit?
And the answer is it's not considered to be cleaning because when you clean your house, you don't pull out paint cans. So the only way that you could charge for painting would be if it's unusual wear and tear. So if the child put crayon marks all over the unit, that would be a proper deduction.
All right. And then the 21 days, how do you count it? Is that calendar days, business days?
Calendar days, 21 days.
All right. Well, we're getting close to we do have a few more questions, and I know you have a meeting. Let me look real quick here on this other one. Okay, do we have to print the pictures? Okay, or can we email them? You kind of talked about that. It has to be in your,
Well, yeah, technically you're supposed to mail them, but I can't see a problem if you email the pictures and mail the security deposit itemization.
yeah, and you know what's nice with email is you have it's documented. And maybe you can put it put it off into a file so it's easier to find.
In
Okay, under
fact,
the
why don't you
AOA
put
lease
into your,
form. Oh,
I
what's
was going
that,
to say,
Dennis?
why don't you put into the rental agreement? You can just add this in that all notices can be sent by email. If you have that in there and they agree to that, then you're fine.
All right, under the AOA lease form, if you have a stove in a single family rental, is the tenant or landlord responsible for repairs such as the igniter for the oven?
If you supply an appliance, you being Mr. Landlord, then it's your job to maintain that and repair it if it becomes broken.
All right. Lots of people are wondering about the rules for the interest. Okay.
Yes, if you go to my website, evict123.com, and you go to the legal issues section, you drop down. I have all of the interest for each year going back to, I think, the 1980, believe it or not, of what you have to pay. So that would be in the legal issues on my website, evict123.com. I don't know if you have it on AOA website, do you?
The say that again. I was reading the
Do you
question.
have, sorry, do you have the listed interest on security deposits that's required on your website?
I know our advisors have it. I don't know if it's listed or not.
All right, so you can grab it off of my
Okay,
website
go
at
get it.
evict123.com, legal issues section.
Yeah, so I was just looking, just because I know we only can take like one or two more questions. I was just trying to pick a good one here. John is asking if as rents go up, can you request compensating deposit increase?
And the answer is no. Whatever you got in the beginning is what you get. However, I think I might take that back. I think in the city of Los Angeles, they do state that you can have a corresponding, with every rent increase, you can have a corresponding security deposit increase for the same percentage. So this year it's 3%. So I think you can get a 3% increase on security deposits.
Wouldn't that be good for the whole state if it's 1 month's rent?
No, I don't think so because there's something in the language dealing with security deposits that says whatever you get is what you get
Okay,
at the
okay.
initiation of the tenancy.
All right. Okay, what if damage is concealed by the tenant's belongings and furniture during the walkthrough 15 days prior to vacating and not revealed until they actually vacate? Can
And
compensate?
that's a really good question because the pre-move out inspection is not the whole game. The landlord has the right after the tenant moves out and moves the couch so you see what's going on underneath the couch to give a final accounting. But the pre-move out inspection is to say, hey, this I'm definitely going to be deducting for, and you better take care of it, otherwise it will come off your security deposit.
Okay. Gosh. Okay, and then is there a legal way to require tenants to use a licensed contractor for certain repairs requiring a city permit, such as electrical, roofing repair caused
Yeah,
by install?
if the
Yeah.
tenant's going to do the job, then they got to do it correctly. And if the job requires that it's a licensed uh, workman, then yes, they have to get that licensed repairman there.
All right. Hey, Dennis, let me just look real quick one more time. Diana's got her hand up. Diana, maybe we'll let you ask
Something
your
quick because we're at my hour.
super quick, Diana. Here we go.
Okay,
Last one.
yes, it's in reference to the security deposit refund. When in your lease, it talks about gate cards, mailbox keys, keys like that, and that we charge if they lose it. Is that something that can be deducted from their security deposit if it is included in the rental agreement already, the cost of those individual items?
Technically, if you read the code, it's unusual wear and tear, cleaning, and any rent owed. If you could possibly state that that's part of unusual wear and tear that you didn't return this, but it is a close issue.
All
Okay,
right, hey, Dennis, thank you so much. I can't wait to see you in August next month. It's right around the corner.
And I'm going to be there, and I can't wait for that show to be there. And everybody, come on down. You guys will hear so many lecturers, including myself, And more importantly, there's so many vendors there that you'll be able to literally operate your buildings much more efficiently and economically. And that's what the name of the game is for what we do.
And also, don't forget, everybody, if you missed the emails, if you've missed everything, 3-day notices have been updated. And yeah, so things are different now. Make sure you're using the latest forms, especially for those 3-day notices. But always just download it from the site, because those will be the most up to date. And check with your attorney as always. But anyway, thanks everyone. And we'll see. Hope you all have a good weekend. Take care.